Welcome to freedivorce.com.
This is Christina.
And this is Ed. Today we're going to talk about the basic law concerning the division of assets and debts. We cover the division of particular assets, such as the family home, retirement assets, life insurance policies, and other assets in separate videos. We also cover the division of credit card debts and student loans in separate videos.
Yeah, all divorce agreements must spell out which assets each party is going to keep and which debts each party is going to assume responsibility for paying.
Yes, we live in a community property state. Normally, when parties divorce, the community property assets and the community property debts are going to be divided equally in terms of value. Now, if you own separate property, normally you will keep your separate property and your spouse will keep any separate property they may own.
What is the difference between community property and separate property?
Well, the easiest way to understand what is community property is to start by saying what it is not. Property that is acquired during the marriage is normally going to be community property unless it is separate property. So we're going to start by explaining what separate property is. There are 4 categories of separate property. If the property does not fall into one of the 4 categories of separate property, it is then going to be community property.
What are the 4 categories of separate property?
These are pretty simple. Separate property is going to fall into one of the following 4 categories. First, any property that you owned before marriage that you still own. Second category, any property that you still own that you inherited. Third category, any property that you still own that was gifted to you, and the gift can be from your spouse or it can be a gift from anybody else. And the final category of separate property is property you acquired after the date of separation, after you and your spouse decided that you were going to get a divorce.
What about rents or profits generated by a separate property? Are they also separate property?
That's correct, yes. Separate property is also going to include any rents or any profits generated by your separate property. So for an example, let's say you entered into the marriage with a $100,000 certificate of deposit. The interest that that certificate earns during the marriage is also going to be your separate property. Another example, if you entered into the marriage owning a rental house, that rental house is your separate property because you owned it before marriage. The net rental income generated by that house is going to be your separate property as well.
What if I came into the marriage with separate property funds, but spent the funds during the marriage?
Well, if you used your separate property funds to acquire an asset during the marriage, the new asset will still be your separate property. All right, for an example, let's say you came into the marriage with $20,000 in your savings account. So that's your separate property because you acquired it before marriage. And then you use that separate property money during the marriage to purchase a car. The car would still be your separate property. You just have to trace or prove that the original $20,000 was used to purchase the car and that the car was not purchased with community funds.
What if I inherited $20,000 during my marriage and used that money to buy a new car? Would the car be my separate property?
Sure, it's the same as the example I just mentioned. If you inherited $20,000, the $20,000 would be your separate property because it's an inheritance. If you use the same $20,000 to buy a car, the car will still be your separate property.
All right. What if I come into the marriage with $20,000 of my separate funds that I earned before marriage, and during the marriage I spent the $20,000, not on an asset like a car, but to pay for groceries, utilities, and to go on a vacation?
Well, in that case, the money is gone. There's no existing separate property asset that you can trace the money to, and so there's no longer any separate property asset.
What about a gift? What if my parents gifted me $50,000 during the marriage to use as a down payment on a house?
Well, as I mentioned earlier, gifts are one of the 4 categories of separate property. So the $50,000 would be your separate property, and you would have a right to be reimbursed for the $50,000 upon the sale of the house. Now, I'm assuming the gift was made by your parents just to you and not to you and your spouse. Now, if the $50,000 was received by way of a check from your parents and it was written to you and your spouse, well, then it would likely be community property and not your separate property.
What about wedding gifts? Are wedding gifts from my family my separate property?
No. Wedding gifts are gifts to both of you and are community property. It doesn't matter whose side of the family made the gift.
So, to summarize, separate property is property acquired before the marriage, property acquired by gift, property that is inherited, and property acquired after the date of separation. If it does not fall into one of those four categories, then it is likely community property.
That's correct.
What about debt? Are there such things as community debt and separate debt?
Yes. Separate debt is debt that was incurred prior to marriage. For example, if you borrowed $10,000 from your parents before the date of marriage and never paid it back, upon a divorce, that pre-marriage debt would be your separate debt and it would be assigned to you to pay. Now, debt that is incurred during the marriage, and when I say during the marriage, I mean between the date you get married and the date you separate, well, that debt is generally community debt, but there can be some rare exceptions. If you and your spouse separate and then divorce, debt that is incurred after you and your spouse separated, that is also going to be separate debt. So, for example, let's say if husband and wife separate and the wife then runs up a big credit card bill buying a complete new wardrobe, the new wardrobe will be her separate property because it's an asset she acquired after the date of separation. However, the post-separation credit card charges made to buy that wardrobe will also be her separate debt.
Upon a divorce, separate property goes to the person that owns that separate property, and separate debt is assigned to the person that owns that debt. Is community property and community debt then always equally divided?
Typically, when a couple gets divorced, the parties are going to divide their community assets and their community debts equally. In a contested case, the court is going to try to divide the community assets and the community debts equally. However, in an uncontested case, where you are negotiating a property settlement agreement with your spouse, assets and debts do not have to be divided equally. You're both adults. If you want to agree to a lopsided property division, the court will approve that division. Parties to a divorce are free to divide their assets and divide their debts in any way they want, even if it's a very lopsided division.
The division of assets and debts can be simple if you and your spouse don't own much and don't have much debt. However, if you own a home, have an interest in retirement benefits, own a business, or own other valuable assets, there can be exceedingly complex issues that you must take into consideration before starting settlement discussions. You can watch some of the other Getting Educated videos that cover these assets on our website.
We also have a separate video on reimbursement claims. Reimbursement claims are oftentimes related to the division of assets and debts. As I mentioned earlier, if you use your separate property funds for the down payment on a house that was purchased during the marriage, you will have a separate property reimbursement claim that needs to be taken into consideration when you and your spouse discuss how to divide the equity in the family home. So you want to listen to that reimbursement video. This has been a presentation by freedivorce.com.